Of the school town.
Work on intellectual property right.
So, दो तो हो ही गया।
Hello.
Hello. Good morning.
Good morning, sir. When the meeting will start?
Good morning, sir.
Morning, sir.
Start, sir.
Good morning. Will take 5 more minutes. Please wait.
Okay, sir.
Other join. I'm not gonna join.
So let us start now. Okay, myself is Dr. Sangjukta Chakraborty. I'm the HOD of the Department of CSC at SICOM Skills University. So let us officially start this program today. So am I audible? Please someone confirm. Am I audible to
Yes, ma'am,
everyone?
you're
Okay,
audible.
okay. Thank you, thank you. Okay, so good morning everyone. A warm and hearty welcome to our Honorable VC Sir, Honorable Pro Vice Chancellor Sir Academics, Honorable Pro Vice Chancellor Sir Accreditation, respected Registrar Sir, respected Dean of Doctoral Studies, Dr. Pranavesh Ghosh Sir, respected Finance Officer Sir, respected esteemed guests, all respected principals, sirs and madam, respected library madam, respected convener IIC SSU, faculty members, students, and participants joining us today for this insightful webinar on Intellectual Property Rights Awareness Program, which is organized by Institutions Innovation Council, IICC Skills University, in association with Office of the Controller General of Patents, Designs and Trademarks Department for Promotion of Industry, Internal Trade, Ministry of Commerce and Industry, Government of India, and the webinar is coordinated by Dr. Pranavesh Ghosh, Dean of Doctoral Studies, SICOM Skills University, and Dr. Ramajit Mondal, convener, IIC SSU. It is indeed a privilege to host this session, which aims to spread awareness about intellectual property rights (IPR) and its role in fostering innovation and entrepreneurship. As we all know, in today's knowledge-driven world, protecting intellectual property is essential for sustainable growth, research, and economic development. We take this opportunity to welcome our distinguished speaker, Mr. Arnab Bhattacharya, who will enlighten us on the significance of intellectual property and its role in academia, startups, and industries today. To begin this session, may I now invite Dr. Pranavesh Ghosh, Dean of Doctoral Studies and Academic Coordinator, SICOM Skills University, to deliver the inaugural address. Please, sir, share a few words with all of us. Thank you, sir.
Good morning. Good morning, all the participants, and good morning to Mr. Arnav Bhattacharya. As Madam Shamjit Chakraborty, uh, you know, told a few things about our speaker, and this is our privilege to, like share this seminar. As you all know, our old students, faculties, the members of SSU and outside SSU who joined today's session. And almost 2 years back in 2023, 31st January, we did the same seminar in collaboration with the Intellectual Property of India and NIPAM. And this year, SICOM Skills University's Institution Innovation Cell, Innovation Council, and Patent Office Controller General of Patents, Design and Trademarks of Kolkata office jointly in collaborative manner will deliver this session. Hopefully, every participant, students, faculties of this university and outside of this university, they will get benefited from this. And as you know, the world is changing day by day, and we are really happy to uh, share this session because the intellectual property right is very much important in today's scenario. In case of science, engineering, technology, pharmacy, agriculture, the arts and humanities, legal studies, and everywhere. The legal studies, but it's basically their core area is this patents and IPR. But along with this, all the domain of today's academic scenario is dealing with this intellectual property right. So hopefully, our speaker in this field uh, uh, will get enriched by this session, and hopefully our scenario is the scenario is changing in today's world, and everybody will take a patience to complete this session. After the session, uh, the participants who will participate today's session, they can ask their question to our distinguished speaker for their queries. And now I'll not waste any more time. I'm handing it over to Dr. Sanjit Chakraborty, today's co-host, to invite our speaker, Mr. Arnav Bhattacharya, for his session. Thank you.
Thank you, sir, for your valuable insights. Your words truly set the stage for today's discussion. Thank you once more, sir. Okay, so now moving forward, we have the privilege of hearing from our esteemed speaker, Mr. Arnav Bhattacharya, who has vast experience in IP laws, patent filing, copyrights, trademarks, and innovation management. Regarding his educational qualifications, he has acquired Bachelor of Engineering in Electrical Engineering from the prestigious Jadavpur University, Kolkata in the year 2015. After that, he has completed Masters in Technology from the Indian Institute of Technology, Delhi in the year 2019. Regarding his professional experience, he has served as Senior Engineer Electrical in Larsen & Toubro Consultation Limited from the year 2015 to 2017, and currently he is the Examiner of Patents and Designs Grade A Gazetted Officer, Patent Office Kolkata, DPIIT, Ministry of Commerce and Industry, Government of India. His area of expertise are prior art search and patentability analysis in examination of patent applications and as an examiner of International Search Authority. So we are eager to learn from your expertise, sir. So the virtual floor is now yours, sir. Please, sir. Thank you.
Am I audible? Hello. Am I audible to everyone?
Yes, sir, you are audible.
Okay, thank
Please continue.
Okay, so a very good morning to all the respected participants. I welcome you all to this awareness program on intellectual property rights. To begin with the session, at first, we should try to understand what is the topic of discussion, meaning of the topic of our discussion, that is intellectual property rights. If we go word by word, the first term that is coming out is intellectual. Intellectual means anything that is originating from our mind. Okay, it can be of any thought, idea, creativity, okay, any innovative idea. Okay, whatever is generating in our mind, we call them as intellectual. Okay. The next is property. Basically, property is divided into two types. One is tangible properties, which refers to physical properties that we see in our day-to-day life, like gold, car, house, equipments, furnitures. But apart from that, there are also another type of properties which are not physical properties, but creations of minds or creations of human intellect. Examples include inventions, literary, artistic works, symbols. So these type of properties are called as intangible properties. Our topic of today's discussion, intellectual property is also a type of intangible property. And the last part remaining is right. So whatever thoughts or ideas is generated in our mind, okay, they are actually in possession of us because we are the creators of those ideas. So since they are in possession with us, so therefore it can be called as our property. Okay. And since it is our property, so we have got a legal entitlement to it. Okay, that is rights to that particular property. So the legal right that protects our intellectual property is called as intellectual property right. Again, that I have discussed so far, intellectual property refers to creations of minds like inventions, literary, artistic works, design, symbols, names used in commerce. By intellectual, we means possessing or showing mental capacity, property, anything that is owned by a person or entity, Rights are legal entitlement, accepted and protected by law. So a legal right that protects our intellectual property is called as intellectual property right. Now, why are we discussing this particular topic? What is the importance specifically? So first of all, it's a legal right. Okay, all IPR laws are actually enacted, all intellectual property rights are enacted by the country specific laws. For in case of India, we have got the Indian laws of different classifications of IPRs. And second part is that they are exclusive rights. Exclusive rights means it protects the creators, okay, and it excludes others from utilizing that particular IP. Okay, so it's a very exclusive right aimed to protect only the creators. The third importance is that suppose you have obtained an intellectual property in your name, that means you are an IP rights holder, but you cannot, you need to take help of some third party industry or any other organization to actually disseminate your IP, okay, for the public good or the public interest, right? Suppose you own an intellectual property for your invention vaccine, okay, so but in order to use it for public health, you cannot produce, you need some help to produce it in large quantities, okay, to ultimately serve the purpose. So for that, what you can do is that you can transfer your IP right, you can assign your IP right, you can even sell that particular IP right to any other organization, company, or any other person to ultimately serve the purpose. So basically what I'm trying to say is that IP can be commercialized. It can also be used as a source of income or as a tool to earn money. And in today's knowledge economy is a very essential business asset. Now, like other property, IP can be sold, it can be bought, it can be assigned, it can be leased, or it can be rent. It can be passed under a will to a legal heir. It can also be assigned. Role of IP as an intangible property: it protects the economic rights of creators, it prevents commercial exploitation, it increases the capital expenditure, and it helps or promotes transfer of technology as well as cultural development. Now, coming into classifications of IPR. So IPR is classified into several types, and in this awareness session, we shall discuss a very brief overview about each and every classification. But to help you understand and remember in future each and every classification in a very simple manner, I shall try to give some very simple day-to-day life examples against each and every classification. For example, for the first classification that we can see is patent. From now onwards, whenever you hear the term patent in future, always remember only one word, that is invention, because patent only protect invention, not any other things. Yes, not all inventions can be protected by patents, but all patents are definitely inventions. Next is designs. Uh, we are already familiar with this term, the shape configuration that we see, the shape configuration applied to an article, like the design of the sari, the design of the blades of the fan, any shape of the smartphone. Okay, so they are all protected with the help of designs. Next is trademarks. Brand name, brand logo, brand symbol like Pepsi, Coca-Cola, Nike, Adidas, okay, that we can see in different products are actually protected with the help of trademarks. For geographical indications, popular examples are Bangla Rasgulla, Darjeeling tea, Nagpur orange, Bardhaman Sitapok Mihidana, etc. are protected with the help of GIs or geographical indications. Next is copyrights. Literary artistic works like books, novels, literatures, paintings, songs, films, music, etc. are protected with the help of copyrights. Next, we have got semiconductor integrated circuit layout designs. The small IC or electronic elements that are present inside the electronic devices, the mode of arrangement of those elements or the interconnection is actually protected with the help of semiconductor integrated circuit layout designs. And last but not the least, we have got protection of plant varieties. It refers to different protection of breeds of seeds as well as farmers' rights to produce and cultivate them. Next, we shall see how different IPR classifications can be present in a single product also. So the product that we are seeing is a smartphone. At the top of the smartphone, the word Samsung is written in a particular fashion. Okay, and almost all the products of Samsung, which are manufactured by Samsung, are actually embossed in this particular fashion, right? So this Samsung name is basically the brand name, which is protected with the help of trademarks. Next, whenever we purchase any device, we usually get a small user manual. Okay, that contains different identity as well as operational informations about that particular device. So since that small booklet user manual is published by the manufacturer, so therefore it will be protected with the help of copyrights. Next, the shape of the smartphone, the position of the buttons, all the aesthetic or outside features are actually protected with the help of designs. And the technology behind the smartphone, the data processing methods, user interface, okay, whatever it is, as well as the display or the user interface, that will be protected with the help of patents because they refer to inventions. And the shape will be protected with the help of designs. And whatever is inside the electronic device, the arrangement of electronic elements, that will be protected with the help of SICLD. So in this way, different IPR elements, IPR classifications can be present in a single product also. Next, we shall see the creation about IPR. How IPR is actually created. Since our brain is involved, so definitely it is called as intellectual. The ideas or thought process will be generated from our mind. But please try to remember that, okay, whatever ideas or thought process, however creative or innovative it may be, after generation, it is not called as intellectual property yet, because we need to materialize or convert those ideas into process or product or in the form of expressions. Okay, using all the necessary resources, we need to materialize those ideas into process, product, or in the form of expressions. Only then it can be called as our intellectual property. For example, suppose you have got a song in your mind, you are thinking about a new song, but unless and otherwise you compose the lyrics, you add music to it, and ultimately, whenever you publish that particular song in any format, then only it can be called as your intellectual property, which can be further protected by intellectual property right. Next is utilization. IP can be used for personal use or it can be used for academic purpose also. It can be licensed or assigned or transferred to any other person or company. It can be used as a business tool in case of franchise as well as merchandise models. So in this way, IPR can be used as a business tool to have a source of income or a method to earn money. Next is the life cycle of intellectual property. It starts with the creation, and after creation, it is our duty to protect it. And after protecting, it should be utilized. It can be commercialized or any other purpose. And after utilizing it, we need to also to ensure that it is enforced and no other unauthorized unauthorized use is being done. So enforcing is also mandatory. So after enforcing, then the inventor or the IP creator will be motivated to create more IPs. So in this way, the life cycle progresses. Next, we shall move into the first classification, which is patents. I already told you, whenever you hear the term patent, only remember one word, that is invention. So what's a patent? It's an IP right or the legal right to protect invention for a limited period of time. In exchange for full disclosure of the invention, that means you need to disclose your invention to the government, then only you are entitled to get the protection in terms of patent. And it's a territorial right. That means a patent which is granted in India will be valid within India only. It will not be valid outside of India. An exclusive right, as I have already discussed. Now the term of patent is 20 years from the date of filing or the international filing date, whichever is applicable. And it's a one-time protection. After 20 years, it cannot be renewed or reapplied. So inventions can be a product or process. It can range from small products like uh, paper clips to large products like bridges also. And we have already come across, we have already read about several scientists who have got famous inventions in their names, like Thomas Alva Edison, who invented phonograph, Alexander Graham Bell, who invented telephone, Wright brothers, the aeroplane, Louis Pasteur, rabies vaccination, Alexander Fleming, the penicillin. So these are some of the famous scientists with their famous inventions. Another famous invention is this electric lamp. It was invented and protected by Thomas Alva Edison in the year 1880 in the United States. Another example is this particular shoe. It was worn by the famous dancer Michael Jackson, who used to perform his signature moves by wearing this particular shoe. Okay, so since it is his invention, so therefore he had obtained a patent. He had protected it by obtaining patent number US in the United States. In this number US 5255452A. For the cricket lovers, we have got a very popular invention which is almost seen in every cricket matches, which is called as the LED stumps. Okay, this is also an invention invented by an Australian inventor, Bronsey Ackerman, and he had protected his invention by filing and getting multiple patents in different countries. Since it's a patented invention, now whenever any cricket organizing body like BCCI or ICC, if they wish to use this particular invention in any of their matches, so they need to obtain the permission of the inventor because it's a patented product. So that process of obtaining permission is commercially called as licensing. Okay, so and you will be very much surprised to know that the cost of the licensing or the licensing fees that is charged for using this particular invention is around 25 lakhs for a single set. Okay, so for a particular match containing 2 sets, it will cost around 50 lakhs. Okay, so only 50 lakhs is the licensing fee charged by the inventor or the company that is owning the patent for using this patented product. Okay, so you may be realizing that how much powerful the intellectual property is actually. Okay, not only that, we may have seen in earlier days when famous cricketers like MS Dhoni, they used to take a single stump from the set, okay, to I mean after the victory of the cricket match, right? But nowadays it is almost never seen because the inventor has strictly declared it in its terms and conditions that no single stump can be taken from this set because all the sets are connected together. Okay, and plucking a single stump from this set will render the whole set useless. Okay, so the inventor can not only charge the license fees, they can also dictate the terms and conditions of the use of their invention. Another famous Indian invention is this electronic voting machine, which is very popular, and it was invented by Bharat Electronics Limited, and they have obtained the patent in the year 2005. Now the youngest Indian inventor is Vishalini NC. This girl had obtained a patent for a multifunctional life rescue flood house. This is her invention at the age of 6 years. And this boy from Hooghly Collegiate School had obtained a patent for his invention, a touch-free portable hand sanitizer. And so these are some of the famous inventors from India as well as abroad. Next, we shall go into the designs. So as already mentioned, the shape, configuration, pattern, ornament, or composition of lines and colors. Okay, it should be applied to an article. That means all the aesthetic features, and it should be judged by the eye. So these are called as designs. The term of the design is 10 years and it can be extended to 5 more years, that is total maximum 15 years. Now for a design to be protected, it should be new or original. It should be restricted to the feature of shape, configuration, pattern or ornament. It should be applied to an article. It should be applied by an industrial process, and it should be appealing to the eye. So these are some criteria for protection of industrial designs. So these are some of the examples of design protection that we can see the shape configurations of different products. Here we can see how the shape of the Coca-Cola bottle is evolving over the period of time. Okay, so whenever two or more products have the same designs and are being sold together, we call them as set. Very popularly, we use this term, the jewelry set, the set of teapots, the sofa set. So these are called as sets. So this is the original Coca-Cola bottle design. It was granted as a design patent in the year 1915 to the company Root Glass Company. So whenever an applicant registers a design, so he or she will receive a certificate of registration of design in this format. Next, we shall go into trademarks. So as already mentioned, the brand logo, symbols, okay, names can be protected with the help of trademark. Now the question arises, actually trademark is an optional thing. Okay, if you own a business or if you are associated with any business or company, you need not require to have a trademark. Okay, it is absolutely an optional feature. But we can see some big companies like Samsung that we have already seen, Apple, okay, they all have got a trademark. So what is the advantage? The first advantage is the identification of the goods or services. Okay, by having a logo or a trademark, a registered logo, okay, that will help those products to get identified very easily. And the next part is the creation of brand reputation. Okay, if they are if the products are definitely good or of good qualities, so therefore it will be in a very much demand to the consumers, and therefore it will ultimately boost the brand reputation by using those registered logos in case of trademarks. And it also protects the infringement because it's a legal right. So any unauthorized use of that particular logos or trademark protected logos will definitely attract the infringement or any legal troubles. And it also differentiates the product because it serves as a unique brand name or logos, and it should not be written in a very confusing manner. So what are the subject matter of trademarks? First, the product marks are there, like Relaxo, Bisleri. The service marks, Infosys, TripAdvisor. Certification marks like BIS, hallmarks. Tagline slogans, just do it, life's good. They can also be protected with the help of trademarks. Sound marks can also be protected like the Intel sound, the Nokia sound. They can also be protected with the help of trademarks. Shape marks are there as well as corrective marks like CA and CII. Now, whenever two or more products have the same trademark, have different trademarks, but they belong to a same company, like Tata. They can have Tata Steel, they can have Tata Tea, okay, for different products, but parent company is same. So their trademarks can be clubbed together and called as series or associated trademarks. Okay, same is the case of with Amul and Tata. Now, whenever the word TM is written beside the trademark logo, it means that the application has been filed regarding that particular brand name or logo, but they are yet to be registered as a trademark. So then they will write as a TM. But if the trademark is registered, then they will mention this R inside a circle logo beside that particular trademark logo. Okay, very popular example is whenever we see the Bapuji cake, okay, the packet, we can see in the red ink this symbol of R inside a circle is mentioned. That means the Bapuji brand name as well as their product is a registered trademark. Next, we move into the copyrights. So, as already mentioned, copyright includes literary and artistic works, but there is a very subtle difference between copyrights and other intellectual property rights. So what is that particular difference? The difference is like that copyright is an automatic right. That means whenever you publish any article that can be a subject matter of copyright, you get an automatic copyright. You need not to register to the copyright registry and then get a registration certificate. Okay, that is an optional feature. So it's an automatic right and it starts from the date that you have published. But for other IPR rights like patents, design, trademarks, you need to apply to the respective offices in online as well as offline mode, and you need to it will go through some prescribed processes. Okay, and if all the conditions are fulfilled, then only that particular right is granted. Whereas copyright is an automatic right. It starts from the date that you have already published. And it includes a bundle of rights, like a music video can include different rights like the copyright of the lyricist, the copyright of the music, the copyright of that notes, lyrics. Okay, so different rights can be clubbed together and called as bundle of right in case of copyrights. And like other intellectual property right, copyright cannot protect your idea. It needs to be converted into expressions. Now, what are the subject matter of copyright? So first, literary works, which includes the books, novels, literatures. The next is the dramatic works, which includes the theater, dramas. Next is sound recording works. Okay, and another is artistic works like paintings are also there. Musical works, notes. Okay, cinematography, films, movies can also be protected with the help of copyrights. Now, regarding the rights of the author, copyright has got two types of rights. One is economic rights, which can be transferred to any other, like the rights that is exchanged between the author and the publisher in case of publication of their journals or books. But the publisher cannot do like that. The publisher cannot change the name of the author, okay, because the moral right, that is the work of the, that is the name of the author who's created this particular work, okay, that will stay with the author always. And it is non-transferable right. Now, regarding term of protection, different subject matter of copyright have got different terms of protection. Like for published literary or dramatic, artistic and musical works, the term of protection is lifetime of the author. That means how long the author is alive, and up to 60 years after his or her death, the work is protected. Like example, the works of poet Rabindranath Tagore, okay, it was copyrighted to originate to Vishwa Bharati Publications. Now, after the poet's death and 60 years, that is 2001, the copyright was protected, and after that the copyright got lapsed. Now, as on date, any publisher can publish the works of poet Rabindranath Tagore because the copyright term has got expired. Now, for cinematography, film and sound recording, it is 60 years from the date of publications. Broadcast reproduction right is 25 years and performance right is 50 years. So different subject matter of copyright has got different terms of protection. Now, who are the authors of the work who are entitled to get the copyright? So the creators, namely, in case of literary or dramatic work, it is the author. Music work, it is the music composer. Other than the photograph, it is the artist. For photograph, it is the photographer. For cinematography, film and sound recording, the right stays with the producer. For literary, dramatic, musical or artistic works, which is computer generated, it refers to the creator of that particular work. Next is SICLD. So this particular classification of IP is now getting much more prominent due to the rapid development of this technology with the new state-of-the-art technology that are coming nowadays. So let us try to have a look about this particular IP with a very simple example. Like in earlier days, a few years before, we used to see a smartphone which has got a single camera in it, right? And we used to do all our stuffs by using that particular single camera. But nowadays we are seeing that the same smartphone has got 4 cameras, AI cameras as well as IR cameras, okay, and all this type of cameras are being embedded in it, right? So we are adding functional elements, right? But the size of the phone or the size of the smartphone is remaining the same. So how is it possible? So we are adding functional elements like cameras, but we are arranging those elements in such a way that the space of the device remains same, okay, or the device gets more and more compact. So to protect this arrangement, what we need is SICLT, that is Semiconductor Integrated Circuit Layout Designs. So with the rapid advancement of technology, so this particular field of IP is gaining much more prominence. Next, we have got the geographical indications. It is called as invaluable treasures of incredible India. But we should know first what's the GI. So if we go by the example, the first example that we can see is Darjeeling tea. So what is the product here? The product is a tea. Where from it is sourced? It is sourced from the Darjeeling Himalaya region. Okay, and the tea which is sourced from the Darjeeling Himalaya region is of very good, rich quality as well as taste. Okay, those who are aware of it, they might know, right? So to recognize this good quality tea or any good quality product which is famous from a geographical region like Darjeeling and is very much good in reputation or quality by virtue of that origin, so that recognition is given through geographical indications. Okay, so it's a identification, and it examples include the Makrana marble from Rajasthan, Babili Veena from Andhra Pradesh. So different products from different corners of our country, okay, can be registered as a geographical indication. So now what are those products? The examples include the Ratlami Save, the Kanchipuram silk. Okay, so these are the Kanchipuram silk saree from Tamil Nadu. So these are sourced from different corners of our country. So what are the types of good eligible for GIs? It is called as architectural goods like Darjeeling tea, Nagpur orange, manufactured goods like handicrafts, food crafts, and natural goods like Makrana marble, Balu Patthar. Okay, so these can be recognized with the help of GIs. And please try to remember that whatever products that we shall discuss in this particular chapter are all registered GI products, which is very commonly or loosely called as GI tagged products. Okay, that means they have already been identified and registered as a GI. But we are all aware that in India, in different corners of our country, there exist numerous products of these qualities, okay, which are famous for this particular location, but they are yet to be identified as a GI. Okay, so our aim of this IPR awareness is to understand the value of these products. Okay, what is the importance of these products, and to help them get their dues by recognizing it. Now, what are the benefits of GIs? Now, it provides the authorized user the exclusive right to use the GI on the specific goods, and the registered authors can initiate infringement actions if any unauthorized use is being found. With the protection assured, the market is developed, and piracy and counterfeits are actually removed. Consumers are guaranteed of the genuineness and authentication of those products. And since major GIs are produced in the rural part of our country, so it will definitely boost the rural economy, their recognition, and marketplace access is also there. Natural resources can be recognized as well as saves, and it also preserves the cultural identity of that particular location. Other examples of GI includes the Katputlis of Rajasthan, the Kashmir saffron, the Telangana Telia Rumal, okay, Madhubani paintings from Bihar, Andhra Pradesh Tirupati Laddu. So these are all examples of registered GI products. In case of West Bengal, we have got a very famous GI like Bangla Rasgulla, which was registered as a geographical indications in the year 2018. Other GI tags includes the Sitabhog Mihidana of Bardhaman district, the Madur, okay, Bakura terracotta handicraft, the Chou mask of Purulia, Pokhara. Okay, so they are all registered as a geographical indications in case of West Bengal. And in the last year, the Tangail sari, Gorod sari, as well as the Korial sari. So these are registered as a geographical indications. And other rice varieties are also included, which are recognized as a geographical indication. So whenever a product is registered as a GI, the applicant will receive a certificate of registration in this format. So from our morning tea to our clothes that we are wearing, the watch that we are wearing. Okay, so they all contain intellectual property in it. So intellectual property is present in our day-to-day life. We are already engaging with it, but we need to understand its value, and we need to promote our own intellectual properties in future to protect our creativity in case of New India. So now regarding the validity of IP, for the patents it is 20 years from the filing date, and there is nothing called global or international patent. For designs it is 10 years and it can be extended to 5 more years. For trademark and GIs they are indefinite, but they need to be renewed periodically. For copyright, different subject matter have got different terms of protection. For SICLD it is 10 years from the application date. Now who can apply? So geographical indications cannot be applied by any individual person. It belongs to the community. So any association or representative of the particular community or location can only file and protect the GIs. Okay, so but other than GI, any person, individual, a group of individuals, startups, educational institutions, small entity, etc. can file and protect other IPRs. And all IP rights are territorial in nature. Any IP which is granted in India will valid within India only. It will not be valid in foreign countries. So this is the current application statuses of different IP applications for a period of 5 years. As we can see, it is having a very stable growth, and we shall expect more IP filings so that more people of our country can understand their creativity and innovations, and then definitely ensure their protection by filing and protecting their intellectual properties. And some points to remember is first protect then publish. If you are opting for publication of your research in any journal or scientific manuals, what we suggest is that first you apply for protection. If it is related to invention, it should be applied for protection of patents. Then it can be, after that, it can be pursued in publication in other journals. And now rights are territorial, and as already mentioned, registration is done by the sovereign authority. All IP rights are granted by the government of India. In case of India, the rights are for limited period of time. No automatic relief is there. Infringement suit need to be filed whenever your IP is getting unauthorized access. Renewal fees need to be paid for some IPRs. An appointment of patent agent or any IPR professional is not compulsory. The applicant can file and sign the document himself or herself, and our e-filing portal is available in our Government of India IP India website. Now going to career opportunities in IPR. So it has got actually two types of job opportunities, this domain. One is government job, which includes the examiner of patents and designs, the examiner of trademark and GI, and the examiner of copyrights. For others, the patent agent, the trademark agent, GRFs, SRFs, research fellows in patent facilitation centers, and patent litigation and other opportunities available in the private sectors. So these are some of the job opportunities that are available in the domain of IP. So these are some of the important links which are available in our IP India website. Any interested person can visit our IP India Government of India Intellectual Property Office website and can check all the FAQs and other documents themselves. So thank you very much. This completes the presentation part. Now we shall move on to the next segment as well as other doubts and queries.
Thank you so much, sir. That was indeed an enlightening session for sharing your knowledge on intellectual property, copyrights, trademarks, and its role in shaping the future of research and entrepreneurship. Now it's time for our question and answer session. So participants, if you have any queries, please feel free to drop them in the chat box, or you can unmute yourself to ask question directly to Sir Dr. Mr. Arno Bhattacharya, sir. So participants, you are requested to ask questions if you have any. Participants can drop their questions in the chat box as well as they are free to ask questions directly to sir also.
Hello, sir. Am I audible, sir?
Yes, you're audible.
Okay, sir. Sir, I have a question. I can't understand what is the difference in copyright and patent because those points are same, na?
Patent is
Copyright
always
and
referring to invention. Invention can be a product or a process. Okay, suppose you have invented a drone. Okay, so that's a product. Or you can also invent a method of producing a particular product, like a method of producing a pen. Okay, for an example. So that process and product is called as invention, and that can be protected with the help of patent. Now, copyright is literary artistic works like novels, book. You may write a book, you may write a song, you may write a lyrics. Okay, so that particular publication of literary or artistic works is protected with the help of copyright. Patent is invention, copyright is literature. Just remember it like that.
But sir, when I apply patent, then I have to pay the charges. But copyright is
Copyright is an
non-chargeable.
automatic. Not everything is chargeable only whenever you are applying for protection. But copyright is an automatic right. Okay, you can or cannot apply. You may not apply. That is as per your wish. But for patent, you need to apply to the patent office with all the aspects of your invention, and will then the government of India will follow certain rules and guidelines as mentioned in the Patents Act. And ultimately, if we fulfill all the requirements, then you will get the patent granted. Okay, but copyright is an automatic right.
Okay, understand.
Sir, I have a question.
Yes, please.
Sir, how semiconductor integrated circuit layout can help our economy and agriculture?
Yeah, it is not related to agriculture, I think, but it is regarding the technological advancement. Okay, as I've already mentioned in
Good morning,
earlier
sir.
days, we used to have a smartphone of one camera, right? Nowadays we are seeing more cameras, AI cameras as well as okay. So all these products are getting inserted in the mobile or smartphone, but the space is remaining same, or the devices are
Morning,
getting
sir.
much more compact. Okay, so in order to do that, we need to arrange those devices in such a way that the space is
Sir, how
remaining
it
same.
can help our economy?
Yes, because it will definitely make more compact devices in case of
Thanks a lot. First of
smartphones.
all, thanks a
Okay,
lot.
and therefore it will definitely
I have a
be
question.
relating to the compactness of the devices, and therefore it will incur much more demand, and hence they will boost much more economy like that.
Sir, one more question, please.
Please.
Sir, if I am inventing and I'm doing an invention, so I need to do a patent. So what will be the application and cost and
Yeah, the
like that?
cost is if you
If I am
are filing
developing
as
an
an
Android app,
individual, if you're filing as an individual, then the filing fees is 1600, and the request for examination is 4000. So the minimum filing fee is 5600. Okay, that is that you need to pay as an individual if you're filing for patent.
I am developing an
Thank you,
Android
sir.
app with healthcare product planning.
Okay, so there are some questions in the chat box. I'm just
Yeah.
I'm trying to answer. If a
Hello, sir.
Hello,
person,
sir.
yes, please.
Hello, sir.
Yes, yes, yes.
Sir,
Uh,
I have a question, sir. Hello, sir.
Please, please.
Hello.
Yeah, please
Hello.
proceed with your question.
Actually, sir, once you tell the trademark, so in the now market, as like Apple trademark use another third party company. So
Planning.
how to off this use of this logo?
Yes, if they are using it unauthorizingly, that is without informing to Apple or without the consent of the Apple company or the parent company, which is owning
Serving.
that particular trademark. So, if they are using it
I am
unauthorizingly,
developing
so
an
that is
Android app
illegal.
with healthcare project planning,
Okay, so
which
that
is
is
serving
illegal. So it should never be used. And if it's used, then the Apple can definitely sue them. Okay, to that they are
serve the
using,
So
unauthorized trademarks.
so sir, many person, many company, third party company use Apple logo. So why company not take necessary action against this
Yeah,
personal
they
this from
may take
individual?
necessary action, but it may not be, they may not inform us. Okay, so we may not get those informations, but they definitely take the actions
Sir,
because
I have a one answer because the Apple why not taking action because they are promoting their brand without promotion.
that is also true. But the ultimately the profit, okay, so or the revenue earning, okay, that will be the third party
But
will
if
get,
a
right?
person is not earning much and he is buying the first copy product,
Yeah.
whenever he will earn money, then he
Yes,
will
yes, yes.
always
That is.
buy the iPhone.
Yes, that is also true. Okay, so what the big companies what they do is that they check, okay, what amount of money the unauthorized user or the unauthorized seller is actually earning. If they are earning big, so then they will sue them, and they will charge actually the penalties. Okay, that will be worth of crores rupees. Okay, that will depend upon the revenue. So that is actually illegal as per the law.
I have a question, please.
Yes.
Yes, if the person have a overseas property
Mm-hmm.
and he is belonging to the, the country like India,
Mm-hmm.
so in which way the property rights will be controlled, or if there is any goods
What is
rights?
property related, ma'am? Intellectual property you are talking about, or any
Yes,
tangible property?
yes, intellectual
Okay,
property, but
it can be protected. Okay, you can file in India as a foreign, I mean as a NRI also. That only need to have an address for service. You may invent something in foreign country also, but you can definitely get it patented in India. Okay, several foreign companies which have got their own invention, like for example Qualcomm, okay, and other all the mobile communication companies. Okay, so they have got the business in India, so they have invented in different country, but they can apply and protect their inventions in the India also. It can be done.
okay. Yes, yes. And
Sir,
in
I
the
have a
case
question,
of,
sir. Sir, I have a question, sir.
Please.
Good morning, sir. First of all, thanks a lot for the great session.
Yes.
Hello, sir. If I am developing an Android app for
Mm-hmm.
healthcare project planning, which is especially serve the service industry of healthcare,
Mm-hmm.
especially I want to protect my healthcare product planning and and the Android apps also. So
Are you
how can I?
referring to software products, right?
Yeah.
Software products, if you're writing as a code like all these things, you are programming something, so that the applicable protect IPR is copyright. Okay. But in case of patent, if you are going for the protection as your invention, so then it needs to be what we suggest is not needs to be, it should be some hardware or software combination. Okay, then only you can get the protection. Otherwise, only software computer program parts say okay, they are actually non-patentable inventions, so it cannot be granted patent. But if you are going from technical advancement, or if you are having some software hardware combination, then definitely you will get the patent protected.
Sir, can you give your LinkedIn account in chat box?
I can give you my official email ID. Okay, then you can definitely approach whenever you have got any doubts and queries. Okay, so some questions in the chat box. Okay, I should think. Okay, so the first is, what criteria does my invention have? So there are certain patentability criteria are there. Okay, so one is novelty, inventive step, and industrial applicability. You can search for it, or whenever you listen any advanced lecture about patent, you can definitely get that particular idea. GI, one more time. GI Bangla Rasgulla Darjeeling tea. Okay, so these products like Bardhaman Sitabhog Mihidana. So product is a Sitabhog Mihidana originating from Bardhaman, and they are of good quality and taste because they are originated from Bardhaman. Okay, so these products are protected and identified with the help of GIs. If a person wrongly patented invention, what should do the owner do? The owner can initiate necessary infringement, and if the person who has wrongly protected or wrongly patented the invention found guilty, then the patent will definitely be revoked. There are provisions. How much money, that I have already covered. And I go for patent publication of my research article? Yeah, that's a very good question. If it is already published, we always suggest is to file a corresponding patent application within 1 year from the date of publication. If it is done, then in the Patent Acts or the provisions of law, it is mentioned that you can proceed for patent application if it is within 1 year from the date of publication. But if it is exceeding that particular timeline, then that publication can be cited to reject the patent ultimately. What is the difference between registered and unregistered? If it is registered, it is called as copyright, and it is not registered. For example, it is not even published also. Okay, so it is called as unregistered copyright. But as I have already told you, copyright is an automatic right. Okay, so if you are registering it, that means you are applying through the prescribed process, but definitely it will help you in case of any infringement. No, nothing is stronger than copyright, but the term of copyright is actually larger than patent, but patent protects inventions. So it can include the product or process.
Hello, sir. Hello.
Yes, please.
Yes, sir. Sir, my question is, sir. Sir, many companies are common names like sir Apple, and some company uses Krishna Maruti like this. So, sir, this name is very common for like is Apple is a fruit and the Krishna is a supreme god. So, sir, how to this is common names is patent like any another company is
Patent
doing this
cannot be
because
done. Okay, I think you're talking about trademarks. Okay, so if you are using it only with God's name, okay, it may not be applicable for trademark protection. Okay, but if you are like Apple, they have already designed a logo with it. Okay, and they are actually very popular brand. Okay, they are not new brands. Okay, they are actually very popular. So using that popularity or reputation, they can apply for the trademarks. Okay, but only brand name, logo, if combined, so they can get the protection of trademarks. If a brand name is registered in US but not in India, so don't confuse brand name with patent. Okay, patent is only for invention. Okay, you are talking about trademark, right? So if it is
yes.
registered in US but not in India, okay, so any other brand cannot copy it, okay, legally, because whenever any other brand try to copy that particular brand name, okay, so that brand name can apply for the trademark protection in India also. Okay, that can be done. Okay, and if they are using it unauthorizedly, so therefore it is an illegal thing, and they can also sue that particular brand legally.
Okay, sir. Thank you, sir.
Yeah, how far is AI is going to protect in case of novelty? Okay, so in case of novelty, AI is not important, but in case of inventor it is important. I think you are aware of this famous case, DABUS, okay, wherein the inventor is the AI itself. Okay, so but in India as of now, with the current rule and law, only the human being can be inventors. Okay, so any AI cannot be inventors, but definitely using the AI will definitely solve our problems, and our application of AI in different fields is actually coming, and we are already getting patent applications where AI is being used. Okay, but ultimately it is the process of the product that will serve as the invention. So that will ultimately test the criteria of patentability. Any other doubts or queries? There are certain patentability criteria: novelty, inventive step, and industrial applicability. You can search for it because it it will actually be a long discussion. Okay, of the patentability criteria. So you can search for it. Very basic one is there, and also advanced things. Any other doubt?
Hello, sir. I'm Ruxana Shamim. It's a very informative session. Thank you for your lectures.
Thank you.
And so far my knowledge is concerned that regarding artificial intelligence and regarding intellectual property laws, so intellectual property is a sheer only, the sheer invention or absolutely comes from the human intellect. And that is also comes from the from originality or novelty, whatever we can say, novelty and originality. Now, in case of artificial intelligence, that is nowadays we're hearing about. So, how far if it artificial intelligence is being used in everywhere, and it is going to be going to be used in near future also. Anything which has been originates from artificial intellect, which is though it is manipulated by human intellect, can it be protected? My question was
It
like
can be,
that,
yeah,
whether
it can be protected, ma'am, because we are discussing about the process or product. Okay, what process? AI
yeah,
can be, I mean, made or used by the AI only. But okay, so the ultimate product or process, how it is there. Okay, it can be protected if it's got some technical advancement. Okay, or it can meet the patentability criteria. Okay, it can be protected, but you cannot claim AI as an inventor. Okay, because as of now, the Indian laws, as per the Indian Patents Act, AI or the inventor can only be a human being. Okay, and so AI cannot be an inventor. You can say that we have used AI to ultimately arrive at this process or product that we are claiming as an invention. Okay, that can be done. And if it got some technical advancement to some technical effect, and if it's solving some problems which is existing in the current technologies, it can definitely be patentable.
yes, so that must be originate and genuine, and that should come out from novelty.
Yes.
Okay, thank you so much. Thank you.
I hope there are no other doubts and queries.
Yes, sir. I also think so. Okay, so a big thank you to our esteemed keynote speaker, Mr. Arnav Bhattacharya, sir, for sharing such insightful thoughts and for answering all the questions of our participants so nicely and wonderfully. And thank you to all the participants also for joining this question answer round. So as we have come to the end of this insightful webinar on Intellectual Property Rights Awareness Program, so I would like to request Dr. Pranavesh Ghosh, sir, Dean of Doctoral Studies, SICOM Skills University, to give the vote of thanks. Sir, please. Thank you, sir.
Thank you very much, Dr. Chakraborty, and a very thanks to Mr. Arnav Bhattacharya, Examiner of Patents, Regional Office, Kolkata, Patent Officer, and for his nice presentation in this session. And it was I can say that is a state of the art session and very informative for the participants who attended the session. I should give thanks to Dr. Ramojit Mondol, the convener of the SICOM Skills University Institution IIC. And I should give thanks to the president of the SICOM Skills University IIC, Professor Praveen Mukhopadhyay, Vice Chancellor of this university. And definitely I'll give thanks to all the HODs, principals, faculties of this university, and the dear beloved students of SICOM Skills University, and definitely the PhD scholars who joined this session. And it was a nice session. Definitely we'll try to host this type of session again uh, for the benefit of the students, faculties, and all the stakeholders of this university and outside the university, for society as well, because it's a broad thing, and that's academic domain like science, engineering, technology, law, humanities, arts. Every corner will be benefited with this session. So thank you very much once again on behalf of SICOM Skills University. I am giving a deep thanks or heartfelt thanks to the speaker and Patent Office Kolkata for their time. It was a collaborative move between the SICOM Skills University and the Institution Innovation Council of SICOM Skills University and the Patent Office Kolkata. Thank you very much to Dr. Sanjita Chakraborty. Please conclude the session.
Thank you, sir. Thank you so much, sir. With that, we officially conclude today's webinar. Thank you all for joining us, and we look forward to seeing you at our future events also. Stay safe and keep innovating. Thank you, everyone.